This is Justice, History, and the Law. Lectures, discussions, and interviews from the Robert H. Jackson Center in Jamestown, New York.
April 28, 2004. Supreme Court Clerks Roundtable was held at the Robert H. Jackson Center, featuring clerks from the time of Brown v. Board decision. The Robert Jackson Center was privileged to have 4 of the law clerks who worked in private and in confidence for the 4 principal justices who participated in deciding the Brown case. The law clerks included Barrett Prettyman, Jr., Justice Jackson's clerk, John Fassett, Justice Reed's clerk, Frank Sander, Justice Frankfurter's clerk, and Earl Pollack, Justice Warren's clerk. They came to the Jackson Center to recall the Supreme Court's decision-making process in the famous Brown v. Board of Education case. 50 years since the Brown decision, criticism continues. The decision was not forceful enough. There was not enough progress made to end segregation in public schools. However, despite its flaws, the Brown case is still regarded as the cornerstone in dealing with racial equality.
To welcome all the public and certainly welcome our guests. As this is a production here, hopefully you'll treat this as your living room where you're sitting and listening politely to a conversation among our distinguished guests. Initially, I'd like to thank a variety of folks who made this all possible, the folks from Cummins, HSBC, Phillips Lytle, National Fuel, New York Bar Foundation. They've been our principal corporate sponsors throughout. As I indicated, this is a production which will be in your living room. I would ask that you please turn off all the cell phones, cameras, etc. There'll be a reception downstairs, which will have an opportunity to meet our guests. And that's thanks to the good folks at Habitera, Chautauqua Abstract, Jamestown Bar Association, and the Jamestown Area Chamber of Commerce. Also, take this opportunity to invite everyone to tomorrow's opportunity that we have at the Chautauqua Institution Amphitheater, where the Brown sisters will be sharing in a roundtable discussion on the legacy of Brown versus Board. We thank Chautauqua Institution because I believe it's the first time ever they've opened up the amphitheater this early for this interesting event. I'm Greg Peterson, president of the Robert H. Jackson Center. The Robert H. Jackson Center was established in 2001 and is designed to advance the legacy of Justice Robert H. Jackson through education, exhibitry, and by pursuing the relevancy of his ideas for our present generation. One of our guests today, in a 1958 Virginia Law Review article, said, "It is not too early to predict that his already considerable stature as a judge will grow, not because of his very quotable aphorisms and barbs, but because he possessed a sound and independent judgment. He bestowed a deep respect, even reverence, upon the law he administered. He had a seasoned lawyer's approach to facts, and he understood the true meaning of freedom, that it must be gauged by the freedom sought and not by the group seeking it, that it applies equally to all, and that it carries responsibility." We believe those 1958 statements hold true today, and it's part of that legacy that we are trying to preserve at the Robert H. Jackson Center. The event today, I should point out the author is Barrett Prettyman. The event today is the culmination of a series of events sponsored by the Robert H. Jackson Center over 4 months celebrating the 50th anniversary of the historic decision of Brown versus Board of Education. This roundtable of distinguished lawyers who were the law clerks to the justices who decided that case will be moderated by Professor John Q. Barrett. Professor Barrett is a professor of law at St. John's University in New York City and the Robert H. Jackson Center's Elizabeth S. Lene Fellow. He discovered, edited, and introduced Justice Jackson's That Man, an insider's portrait of Franklin D. Roosevelt. That Man, Jackson's previously unknown and never published memoir of FDR and the New Deal, is a Book of the Month Club and a History Book Club main selection. It's received rave reviews. John Barrett is also writing a biography of Justice Jackson that will include the first inside account of his year, 1945 through 1946, away from the Supreme Court and as the chief American prosecutor of the principal surviving Nazi leaders at the International Military Tribunal in Nuremberg. To set the scene, I refer to a recent New York Times article by Bob Herbert. The baseball season was a month old, and the Brooklyn Dodgers and the New York Giants were fighting for first place in the National League. A war hero named Eisenhower was president. In London, Winston Churchill was adding his voice to the cadre of world leaders engaged in the difficult search for a solution to the war in Indochina. And in Washington, on Monday, May 17, 1954, a warm and muggy spring day in the nation's capital, history was being made. Quote, "We conclude unanimously," said Chief Justice Earl Warren, reading from the court's decision in the case of Oliver Brown et al. Versus the Board of Education of Topeka, that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. That ruling, the most profound of the 20th century, was the essential first step toward a difficult but phenomenal transformation of the American social landscape. Today we hear about the inner workings of that seminal case, which was before the Supreme Court for almost 2 years. Ladies and gentlemen, in order to commence the roundtable discussion, I'd like to introduce Professor John Barrett.
Good morning. My name is John Barrett. I'm a professor of law at St. John's University in New York City and the Elizabeth S. Lennay Fellow here at the Robert H. Jackson Center in Jamestown, New York. The Robert H. Jackson Center is named after and dedicated to the life, work, words, and legacy of Robert H. Jackson, a native of northwestern Pennsylvania, in his private life a lawyer here in this community of Jamestown for 20 years, before he went to Washington and rose through the Roosevelt administration to become the Solicitor General of the United States, the Attorney General of the United States, and then, beginning in 1941, an Associate Justice of the Supreme Court, where he served for the remaining 13 years of his life, except for 1 year away as the chief American prosecutor before the International Military Tribunal at Nuremberg, Germany, following World War II. Justice Jackson was one of the 9 justices serving on the court during the Supreme Court terms 1952 and 1953 as it considered the cases and rendered the decision that we commemorate this spring on the occasion of its 50th anniversary, Brown versus the Board of Education of Topeka, Kansas. The Brown case actually consisted of 5 cases, 4 cases arising from states and 1 case arising from the District of Columbia, which of course is a federal property and not fully a state. The 4 states involved were Kansas, which had the lead billing and thus gives us Brown versus Board of Education from Topeka as the title we use. The other states were Maryland, South Carolina, and Delaware. The court in the Brown case on May 17, 1954, ended segregation of school children by law according to race. It did so in the name of the 14th Amendment, which had been ratified following the Civil War and which guarantees to all persons the equal protection of the law. What the Supreme Court unanimously decided that May 17th, 50 years ago, was that equal protection means that segregation by law has no place in elementary and secondary school education. The court's decision in Brown was the start of legal desegregation in America and the start of the process of racial integration in America, which of course has proven to be an extremely difficult, complex, and unfinished project for our society. But for that start, we here today gather to commemorate and give credit to the Supreme Court. The 9 justices, of course, are no longer with us, but we are privileged to have with us 4 of the law clerks who worked in private, in confidence, for 4 of the principal justices who participated in the court's deciding of the Brown case in May 1954. The law clerks who are with me today are introduced at length in your materials, but I will briefly introduce them and then have them introduce their bosses. The first clerk I'll introduce, sitting directly across from me, is Mr. Earl Pollack. He's a graduate of the University of Minnesota and Northwestern University's Law School. He arrived in Washington in the summer of 1953 to clerk for Chief Justice Fred Vinson, who had been the Chief Justice of the United States since 1946. Chief Justice Vinson, as we will hear, died shortly thereafter, and he was succeeded by Earl Warren, the next Chief Justice of the United States and the author of the court's Brown opinion. Mr. Pollack, following his clerkship, was an attorney in the United States Department of Justice, then relocated to Chicago, where he became a partner in the law firm of Sonnenschein, Nath, and Rosenthal, practicing principally in the field of antitrust law. Mr. Pollack today lives in Sarasota, Florida, and we're pleased to welcome him to the Jackson Center. The next clerk to Mr. Pollack's left is Mr. Frank Sander. Frank Sander was an immigrant to the United States, born in Germany, educated in Boston, public high school in Brookline, Harvard College, and Harvard Law School. Thereafter, he clerked for an appellate judge and then for Justice Frankfurter at the Supreme Court. Following his clerkship with Justice Frankfurter, Mr. Sander also practiced law in the Department of Justice and then in the private sector, and then took the turn into academia. He joined the faculty at Harvard Law School in 1959. He is today the Bussey Professor of Law at Harvard Law School and the director of the Harvard Law School Program on Dispute Resolution. It's a pleasure to welcome Frank Sander to the Jackson Center. The third law clerk, sitting directly across to me, to Earl Pollack's right, is John David Fassett. John Fassett is a graduate of the University of Rochester, and following military service twice in World War II and in Korea, he is a graduate of the Yale Law School. Following his legal education, he became a law clerk to Supreme Court Justice Stanley Reed. And following his work for Justice Reed, returned to Connecticut, where he went into private practice in New Haven, first with the law firm of Wigan and Dana, and then increasingly in corporate America. He rose to become the chairman and CEO of the United Illuminating Company in New England, in New Haven, a major electrical company, and served in that capacity for an extended period of time. Mr. Fassett, in addition to this work career, is a legal biographer. He is the author of New Deal Justice, The Life of Stanley Reed of Kentucky, the principal biography of Justice Reed, and he today resides in North Carolina. It's a pleasure to welcome Jack Fassett to the Jackson Center. The final law clerk with us this morning on my immediate right is E. Barrett Prettyman, Jr. He is a graduate of Yale College and the University of Virginia School of Law. Following law school, he became the final law clerk of Justice Robert H. Jackson. He was with Jackson for the 1953 term of the court, and he was with Jackson for the start of the 1954 term, which was when Justice Jackson died suddenly of a heart attack. Following Justice Jackson's death, Mr. Prettyman was briefly a transitional law clerk for Justice Frankfurter, and following the confirmation of Justice Jackson's successor, John Marshall Harlan, he was a law clerk to Justice Harlan. So he was at the court for 2 years with a total of 3 justices. Following his clerkships, Mr. Prettyman joined the law firm of Hogan and Hartson in Washington, D.C. He left Hogan and Hartson for a time during the Kennedy administration, served in the Department of Justice, returned to Hogan, and at various later points in a distinguished career has also left again to do public service in the District of Columbia government. He is today senior counsel at Hogan and Hartson. He is a vice president of the Supreme Court Historical Society. He's been here previously for one of our roundtable discussions with Justice Jackson's law clerks from the 1950s, and it's a pleasure to welcome Barrett Prettyman back to the Jackson Center. These gentlemen are both protagonists and representatives in our conversation this morning. They are protagonists because each of them was deeply, fundamentally involved in the court's work that emerged in public on May 17th, 1954 as Brown versus Board of Education. But they are here as representatives, they are here as proxies for the justices who were their employers. As each of them left law school, they got one of the most coveted opportunities for a young lawyer entering the workforce, a clerkship with a Supreme Court justice. And I'd like to begin by asking each of them simply to introduce the boss and describe what that meant and who they were arriving to work for as they arrived at the Supreme Court in the summer of 1953. So Earl Pollack, tell us about Chief Justice Fred Vinson.
I arrived at the Supreme Court in June 1953 to become Vinson's law clerk. Unfortunately, I did not have much of an opportunity to discuss much in the way of law with him because this was the summer period, and in early September, shortly after one night when my wife and I had taken the Chief Justice, given him a lift home to his hotel, he died very prematurely. And as a result, my tenure with Chief Justice Vinson was quite brief.
Okay. Give us a little sense of his background. Where was he from in terms of region, and what was his career trajectory that led him to become Chief Justice?
Vinson had come from Kentucky. He had been Secretary of the Treasury, appointed by President Harry Truman, with whom he was very friendly. Subsequently, he was named to the Court of Appeals for the District of Columbia, and then from there he was elevated to the Chief Justiceship of the Supreme Court.
Okay, thank you very much. Jack Fassett, let me turn to you, because in terms of seniority, Stanley Reed was, among the justices represented here, the senior associate justice. As you arrive from Yale to be a law clerk, who was Stanley Reed, and what did it mean to be going to work for him?
Stanley Reed had been born in 1884 in Minerva, Kentucky, a small town outside of Maysville. He had been a country lawyer there and represented tobacco cooperatives until he was touched to come to Washington by the Hoover administration to work as general counsel for the Reconstruction Finance Corporation, which was a Hoover entity. He stayed on when Franklin Roosevelt won his first term, and ended up being made Solicitor General and having the dubious honor of being Solicitor General who argued all of the early New Deal cases, the so-called sick chicken case and the AAA case and all those other ones involving the New Deal statutes that were struck down by the old Supreme Court. Stanley Reed was FDR's second appointment to the court. Hugo Black was the first, and there was a little furor when he was appointed about some of his background, and Stanley Reed, I guess, was deemed to be a safer appointment. He was a country gentleman, a very kind and nice gentleman who had a cosmopolitan education. He'd been brought up in Maysville by a father who was a doctor, and his mother had died at a very early age, but he had gone to Kentucky Wesleyan University and gotten a degree there, and then applied to Yale University, and Yale recognized Kentucky Wesleyan to his degree there to the tune of giving him credit for a year, and and he ultimately became a graduate of the class of 1906 at Yale, and then he went to law school at Virginia and Columbia, and then off to Paris and studied at the Sorbonne.
It's an upward march.
Yeah, and then came back to Maysville to practice.
Now, Frank Sander, let me turn to you. It certainly can't be the case that each member of the court was from Kentucky. Who was Felix Frankfurter, and what did that mean to be arriving as Felix Frankfurter's law clerk?
Well, about as far from Kentucky as you can think of. He was from Vienna, that is Austria, not Virginia.
Okay.
He was a very complex person, hard to capsule in a short profile. very interested in the world of ideas, endless interest in the world of people. I think he wrote more letters and received more letters than anybody I know of.
Corresponded with just about everybody, didn't he?
Absolutely. And I think at Harvard Law School, I guess he was very much revered because he graduated at Harvard Law School and then was in the government some, and then came back to teach and was a longtime faculty member at Harvard Law School, and made an arrangement with one of the professors at Harvard Law School that he would appoint his 2 law clerks each year from people who had worked in the lower courts. So the people who got this opportunity were very lucky. They knew something. It wasn't as much of a mystery for us when we went down to Washington, because we knew the prior law clerks. With very few exceptions, they were all Harvard Law School graduates, which was perhaps a mistake, but it was just Frankfurter's simple way of trying to preserve continuity and get people that were known to the recommenders very well. So he didn't have what these days people write endless letters to 9 justices to try and get a clerkship. In those days with Frankfurter was quite different. I think the other thing that was extraordinary about him, he had no children, so his law clerks really were part of his family, and there was a very close relationship between us and the justice. He and I were both very interested in classical music, and it wouldn't be unusual for him at 11 o'clock at night for him to call me up and say, I just heard this concert by X, Y, or Z. What do you think about this person? That was not atypical. So a complex person who had, I sometimes say he was alternatively exasperating and exhilarating to work for.
Now, Barrett Prettyman, you also later had that opportunity, but your longest clerkship and your initial clerkship was with Robert Jackson. As you arrived in that summer of 1953, who was Robert Jackson as a Justice of the Court?
Well, before I arrived, as a member of the Legal Forum at Virginia Law School, I had him down to speak and spent a delightful weekend with him down there where I really got to know him, even though in a very abbreviated time. And then when I went up for my interview with him in Washington, we had a very wonderful long chat, less about the law than just about theory and life and whatever. And at the end of the interview, he said, you know, we're allowed 2 clerks, but I don't want 2 clerks. I only want 1 clerk. And if you'd be willing to be my only clerk, why, you can have the job. And immediately, of course, I accepted. So that was the end of that. I had not been with an intermediate appellate judge, and therefore was absolutely delighted to be able to go directly from law school into this place on the hill.
All right. So you had no training and twice the responsibility of Frank Sander.
You got it.
But not twice the pay.
No.
Now,
what was it, $5,400 in those days?
$6,000.
Oh, you got more than I did then.
That's where that first clerkship had
There were 2 levels.
had a benefit.
I see.
Now, let's talk about these school segregation cases. The 5 cases came to the court before you gentlemen arrived. The court actually took a while to docket them and put them all in motion, but they had been argued to the court in December of 1952, and then in June of 1953, very shortly before you arrived, the court ordered them re-argued following additional briefing on a long list of topics that the court asked the parties to research and write for the court's benefit. So segregation in many forms had been percolating towards the court, and in the graduate school and law school context had been dealt with by the court, and the court was in the midst of grappling with it as you arrive in the elementary and secondary context. Again, let's begin with Earl Pollack. How did you get oriented to what we today call Brown versus Board of Education as a pending matter?
I became involved directly with the case after Chief Justice Warren arrived in September, and I was assigned to assist him on that.
Let's stay earlier. Was there any contact during the Vincent phase?
There was not. There was not that summer, except that, of course, among the clerks who were already there was tremendous excitement and interest in the pending segregation cases, and a lot of discussion about it. It was the cases were, of course, recognized as constituting the most important issue before the court at that time.
Mm-hmm. Was there discussion with your departing predecessors for any of you about this pending case and what was happening in the court that you were now arriving in the middle of?
If there was, I've managed to forget it after 50 years. One of my great regrets is that I never kept a diary or a journal, which would have been very useful to try to answer questions like that today.
Jack, how about you?
I did have discussion with the one former term clerk that was still there when I arrived on June 20th. They had that order for the re-argument with the questions that you talked about came down on June 8th, and then immediately thereafter the court had two special sessions. The Rosenberg case involving the stay of the execution of the Rosenbergs had occurred there, and it was very acrimonious, and had just been over on the 19th, and I arrived the next day, and the one law clerk still left from the prior term there had an assignment from Justice Reed to do a project having to do with a possible dissent in the segregation cases. And so I did talk to him about that. I also saw the justice for about a half an hour before he took off from there. He was going off to medical center where he had his annual exam, and then to Maysville, Kentucky, where he had a couple of farms yet. And he said he'd be seeing me, and we'd talk at the end of August, or he'd see me when he came back through, going off to a place he'd rented up in New York State, in Oyster Bay, New York, for the month of August. But he'd see me then. But we didn't have too much time to talk, and all he said to me, "Are you up to date on the school segregation cases?" He having hired me and not mentioned the subject at all at the time it was hired. And I said, "I've heard of them, but I don't know much about them." And I didn't even know much about him when I had the lightning strike of getting the clerkship. I didn't know much about Justice Reed and was able to find very little. But he said to me as he was leaving, he said, "Well, there's these shelves over there, and they've got all the records and briefs in the cases. In your spare time, get yourself up to date on them." And so that was a total talk with him about it. And then the clerk that was there filled me in on the job he was doing, but he didn't have too much handle on what had happened at the court with respect to him, because they were being pretty secretive with most of the law clerks about what was going on. And so until I started getting these letters from Justice Reed, first from Durham, and then from Maysville, and then from Oyster Bay, sending me these projects, and when he came back through, we had a long conversation about it, but that's getting ahead of the story.
Right. Frank, how about you?
Well, I like Earl, I'm not quite sure about this, but whether I had any conversations with one of our predecessors, Alex Bickle. His is an important name in the Brown history, because one of the unusual things about Frankfurter is that he didn't use his clerks for routine work like the certiorari petitions, whether the Supreme Court ought to take a case. He handled those himself, but he would assign major tasks to people that really required full concentration for an extended period. And related to the questions for the rehearing, he had asked his prior clerk, Alex Bickle, to make an investigation of the legislative history of the 14th Amendment to see what light it shed on desegregation. In the end, it turned out not much, but being the professor and scholar, he wanted to leave no stone unturned. So this was in process, and I don't know whether I talked with Alex Bickle about this, but we were certainly very aware of that event.
Okay. From Jack's description of his predecessor writing or doing research for Reed in an expected dissent, it sounds like the climate you're arriving in is one where school segregation is losing. It's going to be struck down?
I had no indication of that. When I finally had my long conversation with Justice Reed when he came through at the end of July on his way from Maysville to Oyster Bay, I finally asked him, well, is the court going to decide these cases now? And he said they're going to decide them. They've got the votes. But the indication was that the decision was going to be to strike down Plessy v. Ferguson, and he and some others were going to be in a minority. But he didn't identify who they were going to be. But we had a big argument about it, and that's the state where I learned that long word, critocracy, because I said, well, aren't they going to be reaching the right decision? I think that sounds like, and he said to me, are you one of those people that believes in critocracy? I said, what does that mean? And he referred me to a book or paper that he had there and showed me that critocracy means government by judges. And it was the beginning of a very long dialogue that we had over a period of several months, where we had a very interesting time as he thought over the process of whether he was going to dissent or not. And critocracy was foremost in his mind, that he didn't quite think that this was a role that the judges ought to play.
Barrett, as you were arriving and replacing two clerks all by your lonesome, did you get any transition briefing or any sense of where segregation stood with the court?
I don't recall any discussions with Bill Rehnquist or Don Cronson about the segregation cases, and I was not aware of their now famous memos that they wrote. But the only discussions I had with the justice gave me the impression that the court was in somewhat of disarray. But it was not clear to me, and I'm not sure it was clear to him, where the votes actually lay, because at their one conference, they had decided not to take a vote. Unbeknownst to me, not that long thereafter, in fact, the day before the second argument in Brown, he began writing a concurring opinion, because he assumed that regardless of how the vote went, the justices either would all be writing, or many of them would, that there would be dissents and concurrences and so forth. And so he was trying to get his thoughts down on paper. I didn't see that draft of a concurring opinion until 4 drafts later, when he finally gave it to me.
Okay. We will catch up to that point in the story. The decision to request additional briefing and the postponement of deciding it at the end of that 52 term, does anyone deserve credit for that? Was that Frankfurter and Bickel? Was that Vinson? Do you have any light to shed on that?
Well, I don't know definitely, but I would suspect, both from the nature of the inquiry and what I've read, that it was largely Frankfurter, but it was not Bickel. It was Frankfurter commissioning Bickel to do this and then persuading the court to, as he said somewhere, have this filibuster. I think that was a phrase that's attributed to Frankfurter. It doesn't sound quite true, but in any event, one of his main concerns was the whole theme of judicial restraint, the issue that Jack referred to. So I think putting the thing off because it was a difficult decision and getting more research seems very much in character for him.
I think there was except for a couple of the justices who were anxious to go ahead and have the vote, most of them felt that it would be desirable to have more time. I think Justice Clark and Justice Reed, and I think Justice Jackson as well, all concurred in that. So what they needed was a device to do it. And Justice Frankfurter provided the device by coming up, he drafted these 5 questions, which they issued as their order. The other thing they did, which is significant in that same June 8th period, was to invite the new administration. President Eisenhower's administration had just begun, and they invited, almost directed, the new administration to file a brief with respect to it and take a position on it. And in this new book that just come out, Black, White, and Brown, issued this week, Herb Brownell, who was the Attorney General, has a very interesting and illuminating piece in it telling about what happened at the White House when they were advised that they should participate in this. It required the administration to take a position, and Herb Brownell was very important in convincing the president that they should take a position and that they should oppose school segregation.
Right. Now, that's a nice segue. Much of our discussion, obviously, is going to be legal in nature, or the court's work, of course, is legal in nature, but it's connected to fundamental social realities.
And politics.
And politics. Where were your justices as men on segregation, as you understood them at the starts of your clerkships?
I understood, not directly from Vincent, that he was opposed to overruling Plessy against Ferguson, not because he was a racist, but rather because of his belief that a decision that had lasted that long should not be overturned by the Supreme Court, that as a matter of stare decisis, that it should be done through action by Congress and possibly a constitutional amendment, that it was a matter of judicial process that motivated him to take that view, which in a way was something that also, of course, dominated the thinking of both Frankfurter and Jackson, although they ultimately, of course, took quite a different view.
Right. Frank?
Well, I just wanted to add this footnote. I think that's exactly right what Earl says, because I remember coming to work on September 8th, and in the elevator, the operator said, "Do you know what just happened?" And I said, "No." He said, "Chief Justice Vinson died." And shortly thereafter, Frankfurter got off his now famous line, "That's the first time he believed in God." So this rather suggests that Vinson was clearly in favor of upholding Plessy and Ferguson, and that Frankfurter thought this was a whole new era that was being ushered in.
Right.
I think he said this before the other side of the coin came in, i.e. the appointment of Earl Warren, which was the other really important thing.
Now, Frank, I think that statement of Frankfurter's was made to Phil Ellman, a distinguished clerk of, another distinguished clerk of Frankfurter's, and I think it was not directed solely at the matter of how Vinson was expected to vote, but rather Frankfurter's belief that at long last there was a Chief Justice who was capable of welding the different factions together, something that unfortunately Vinson had not been able to do. It was very much of a fractured court under Vinson, and I think Frankfurter saw the Warren appointment as a chance to overcome that.
Mm-hmm. I think that's...
A number of people have written, and Earl has just stated, the view that Jackson seemed originally to be in favor of upholding Plessy, not striking down segregation, and then came around and changed his view. I think, I disagree with that. I don't think that's what happened, and I think that his unpublished concurring opinion demonstrates it. I think that at that first conference where everybody was expressing their opinion, and a number of justices, including Douglas, wrote down that Jackson appeared to be in that school. Actually, Jackson, being a very, very, very practical person, recognized that school segregation was going to be struck down, and he was willing to go along with that. But he was very worried about all kinds of things. He was worried about not giving direction to the district courts as to how they were going to do this. He was worried about what legal ground the court was going to base its decision upon. He was worried that the court was going to find fault with the school systems, with district court judges, with the South, and so forth. And having expressed all these concerns, I think that writers today and even justices at the conference got the impression that he was negative. And lo and behold, the concurring opinion that he finally gave to me was negative in many respects, but only in those respects. His bottom line was that he was going to go along with the majority because he felt that the Negroes had made such an astonishing progress in the years since the Civil War, the most astonishing progress in history, that even if once there had been any ground for segregating and dividing them based on race, that had long since disappeared, that they were now equal in every respect, and that therefore it was denial of both due process and equal protection to segregate them solely on the basis of the color of their skin. Well, that's how I read Jackson.
Yeah, I do too. And Justice Reed and Justice Jackson were very close together on their thinking on this.
Well, except that Reed was going to dissent.
He was going to write a dissent, but for the same reason that Justice Jackson was voicing. When Justice Jackson circulated his memo in February, where he used the term, it would be a ruthless use of federal judicial power to overrule this, that was sort of Justice Reed's feeling too. His critocracy thought was the same thing, that Justice Reed had been much in favor of fairness for the Negro race. He'd written the famous Smith versus Allwright decision that did away with the Southern white primaries. He'd written a couple of other decisions, but he just did not think the Supreme Court ought to be doing this at the early stages. And so in that sense, they were, well, Justice Jackson would have done a concurrence on that basis. Justice Reed was he was looking for more time. He's in the conference, he said that Plessy probably is going by its day and is no longer good law, but we need more time for things to occur. He was a great believer in time taking care of things, and he was worried about a whole bunch of subjects that he talked to me about. What's going to happen to the black teachers in the schools if we outlaw segregation? They won't be able to teach anymore, that sort of thing. We collected more materials on subjects like that in the early months while he was still thinking about this.
Now, let's introduce perhaps the legal protagonist, Earl Warren, because on that September 8th, 1953, Fred Vinson goes home to his apartment, and it wasn't called Monday Night Football at the time, but he watches an exhibition game on TV and doesn't live to see the morning. And that vacancy is quickly filled on a recess appointment without confirmation by the Senate. Eisenhower appoints Earl Warren and has him in place for the court to begin its term at the start of October. Earl Pollock is one of the law clerks who, I guess, inherits a new chief?
Well, that'd be one way to put it. I think the other two, Vincent Clerks and I, were in something of a state of insecurity because we didn't know what our future was going to be. I think we had temporary appointments by Hugo Black until it was determined whether we were to be retained by Chief Justice Warren. Warren did ask us to continue, and he asked me to stay with him for the second year.
Remind us, because obviously we know him as Chief Justice Warren, but as he's being selected by Eisenhower and as he's arriving, who was Earl Warren on the landscape of this country? And what does it mean for him to be the new chief, put on the court as it's about to start its term, as it's in the middle of these segregation cases?
Warren was a very sharp contrast to Fred Vinson. Both had, of course, extended political backgrounds, but Warren, I guess to use a much hackneyed phrase, was very much of a people person. He would come into a room and he would immediately dominate the scene. He was very impressive physically. He had a big smile. He greeted everyone very warmly, whether he was a messenger, a secretary, or anybody else. It's probably a vestige of his days as a very successful politician. He also seemed to exude a kind of integrity, and he was, by his nature of his very persona, he was a very persuasive gentleman. Mm-hmm. People wanted to agree with him. He put people at ease. He had a patience in dealing with people. There was no throwing his weight around. If anything, he ordinarily showed a high degree of humility, which made it much easier for him to become very friendly with and to be liked by the associate justices.
So he was a Republican governor of California, but he wasn't a sort of muscle-bound weightlifting type.
No, he wasn't. But he was not only a Republican governor, but I think in the previous election for governor, he'd received a nomination by both the Republican and the Democratic parties, indicating the extent of his popularity in California on essentially a nonpartisan basis.
Okay. You've mentioned, Frank, the Frankfurter quip, which is such a good line that obviously he used it with Phil Ellman, yourself, and a number of others about Vincent's death indicating the existence of a God. Do you, I guess Barrett and Jack, do you remember any particular Jackson or Reed reactions to this Vinson replaced by Warren development and what that would mean in the context of these school cases? Barrett?
Well, I don't remember much from Jackson. Frankfurter was in my office a lot because he was in all of our offices a lot. And I do remember that he was thrilled. There was no question. He didn't tell me that quip, but I could tell that he was thrilled. One element, I think everything that Earl said about Warren is correct, but one element that you left out is that he was a very tough man. Underneath that affability, he really expected things to be done in certain ways. When he sent out orders in the court that something was to be changed or whatever, he expected things to move. And I saw him several times where you could tell he was upset, and you didn't want to be at the forefront of that anger when he went that way.
He sure could stroke you, though.
Yeah,
I mean, after the decision, I told fellows the story last night about having a private session with the Chief Justice, that he called me into his office and put his feet up on the desk, and we just chatted, you know, talked about our high schools together. My justice had already left, and he was such a charming man. He could really be convincing, and I think that was a very important aspect. As to the question of expectations right after Vincent died and before Warren was the rumors running around that courthouse on what was going to happen were right. I mean, Justice Reed told me about some of the things that they didn't know who was going to be appointed. It wasn't certain for quite some time that Warren was going to be appointed. But when the appointment was made, Justice Reed said he was so happy. He thought that was a good appointment. So I think he had some of the same thought. He got a little unhappy with his fellow Kentuckian Fred Vinson because of the dissension in the court and the chief not running the court tightly enough. And Reed always thought highly of Charles Evans Hughes, the first Chief Justice, when he was on board, who really knew how to run the court, and neither Harlan Stone nor Vinson really did.
Frank?
Yeah, just a sentence. It's very hard in these 50-year recollections whether you're really recalling something or you're
Making it up.
well, not making it up, but attributing backwards something that you know happened as your own reflection. I find that hard. But I have a very distinct reaction, maybe because I worked for Justice Frankfurter, that it was as if a cloud had been lifted after Warren was appointed. There was just much more hope and a positive outlook, not necessarily how the case was going to be decided, but that this stalemate had been ameliorated and that good things were going to come from Warren's appointment, partly just because of this very impressive personality of Warren's, and he obviously was pouring himself into this job and regarded this as his primary challenge.
You could argue that almost anybody new would have created something of the same feeling, but it was greatly enhanced by his personality.
We had the two occurrences. Vincent died, and then they had the state funeral at the National Cathedral where all of us went by direction, and it was quite an occurrence because we sat right behind our justices, and in the next row sat President Eisenhower and Mamie and the Vice President, his wife, and Harry Truman. Bess wasn't there. And then the justices went off as a group. I think all of them went to Kentucky for the funeral there. And when they came back shortly after, the point was made, and the atmosphere was just different.
As we look back 50 years and recall these powerful events, I am certain that I wasn't there. It is a pleasure to be here. We'll take a short break now and resume again in a few minutes. Thank you.
The Jackson Center is a historical and educational facility dedicated to preserving the legacy of this country lawyer who became Solicitor General, Attorney General, a Justice of the Supreme Court, and served as chief prosecutor at the Nuremberg trials of Nazi war criminals following World War II. To learn more about this program, Robert Jackson, the Jackson Center, and upcoming events, the Jackson Center is located at 305 East 4th Street, Jamestown, New York, and found on the web at www.roberthjackson.org or contacted by telephoning 716-483-6646. This program was made possible through research conducted at the Robert Jackson Center and from articles published in the Post-Journal.